Hello and welcome to Simply Intoxicating. Failure of business is a part of capitalism. With the Insolvency and Bankruptcy Code of 2016 becoming the law of the land, India joins the club. Government has termed it as a historic legislation. The code consolidates the scattered insolvency laws of India into a single piece of legislation. The basic objective of the code is to help a distressed entity to go through a strict, time-bound insolvency resolution process which will be handled by solvency professionals so that it can come out healthier. But if the process fails, then the entity goes for liquidation. The message is loud and clear: survival of the fittest and protection of the economic value of the assets. The Indian banking sector, whose NPAs is almost about to touch the moon, has obviously welcomed the bankruptcy code. Experience from developed jurisdiction has shown that strong insolvency laws has not only promoted entrepreneurial risks, but it has also reduced the cost of borrowings and better behavior by the debtors in terms of fiscal discipline. Now the issue is how the Indian Inc. responds to the bankruptcy code, whether it can bring a turnaround in the overall lending business in India. Now before we discuss these issues with our panelists, let's quickly have a look at the overall scheme of the code. Now, insolvency is a situation where an individual or corporation is unable to meet their financial obligation. Why a bankruptcy code? As per the World's Bank report, in India, 25 cents in a dollar is recovered in 4.5 years compared to 80 cents of dollar in 1.5 years in US. The code is applicable to all entities covered under Companies Act, individuals and partnership firms. Under SICA, 100% net worth erosion was required, whereas under bankruptcy code, any financial default or rupees 1 lakh or above can trigger the insolvency process. In matters of corporate insolvency, application can be filed before the National Company Law Tribunal, which has been recently constituted, and the application can be filed by financial creditor, operational creditor, or the debtor company itself. Once the application is filed before the NCLT, it has to be accepted or rejected within a timeline of 14 days. Let's say if it is accepted, then the insolvency resolution professional is appointed who takes over the management of the company. So no asset stripping happens. Insolvency resolution process will go on for 180 days with a one-time extension of 90 days and simultaneously runs a moratorium period. All decisions have to be approved by at least 75% of voting share of financial creditors. Now, if this insolvency still fails, the company goes for liquidation. Now, straight away going to our panelists to discuss all the issues and to decode this bankruptcy code, we have Mr. Anil Bharadwaj. He is the Secretary General, Federation of Indian Micro and Small and Medium Enterprises. We have Ms. Manisha Dheer. She is the founding and managing partner, Dheer and Dheer Associates. And finally, we have Mr. Dr. Risham Garg, Professor at National Law University, Delhi. Welcome all of you. Let me begin the discussion by asking you, ma'am, we have had DRTs and we were really excited when DRTs came, then came the SARFAESI, and now finally the bankruptcy code. You have seen the evolution of the entire insolvency laws in India. Do you really believe this is going to make a fundamental change? Or is it, it's too premature to to say anything?
Thank you, Sudipto. Well, first of all, I want to say that the bankruptcy code is a systemic change. Creation of a single law in favor of multiplicity of loans. DRT was actually created for the purpose of recovery of loans, and SARFAESI was enacted for enforcement of securities. The new code is a comprehensive legislation where a single default will enable an insolvency professional to take over the businesses of the company, which was not there in the SARFAESI Act nor in the DRT Act. Also, the major shift is from debtors in possession to creditors in possession. So there is a substantial change with respect to what the DRT and SARFAESI was doing and as compared to what the current code is doing. So I think that would answer the question that what is the change, whether it is a substantial change. According to me, it is a very substantial change. A single code taking over the entire laws of the DRTs and the SARFAESI, which will help in faster resolution.
See, first of all, let's see at the conceptual level itself. I think it's definitely a change in paradigm in so many ways. If you look at it, it's very, very comprehensive in the sense that, as ma'am has also mentioned, that in favor of several disjointed laws that were there to recover the debts, it puts them under just one umbrella. So it's a very comprehensive law. Second part of its comprehensivity is with regards to that it applies not only to companies but also to individuals as well as partnership and firms. So under one roof, we are trying to resolve all the problems that are related to recovery of debt and also resolution of insolvency. And apart from that, one another factor, based on the experience that we had of the DRTs and the SICA and related BIFR mechanisms, that it took decades, to resolve a particular issue of insolvency, particularly of reviving a company. So here comes the most important provisions in this new code that are time bound. So 180 days plus 90 and the matter is over. Either you resolve the insolvency, put the company on the revival path or wiped out. So there is no midway, and currently the scope lies, our hope lies that there would not be litigations to derail this process, and we would rather believe that ultimately the spirit of this law will prevail, and 180 days plus 90 days, within that people would be aware or people would know whether there is going to be the resolution or there is going to be the liquidation.
So, we have always been hopeful, but in most of the cases, in some or other way, we end up in the litigation. I'm coming to Dr. Resham Garg. So, what's your take on this? Do you think this will bring a better behavior in the debtors in terms of fiscal discipline? Now, do they have a stake involved so that we can expect, less of defaults, frauds, and in other sense, I would say, can we say that episodes like Kingfisher Airlines, they won't be possible under the bankruptcy code?
As a part of the response, I would like to start by saying that my approach will be analytical. And in the analytical approach, I would refrain from being judgmental, whether it would be successful or not. But certainly, I would prefer to highlight a few issues. Why first we require DRT? Why in the first stage we required the DRT? And then we took lessons from that DRT, RDB5 Act, and enacted the SARFAESI. And then ultimately we were able to identify that we have to take the jurisdiction out of the civil courts and the civil procedure. Then whilst this code was being drafted by the IBC drafting team, if we read the BLRC report number 1, they have considered the analytical study. What were the reasons? One major reason was the individuals which were involved. For example, the court officials, the liquidators, official liquidators. So we wanted to remove that element as well. Today we have identified that yes, we require the reorganization, and we have refrained from using the word restructuring. Instead, we use the term insolvency resolution process. So this is a resolution process which inculcates the reorganization and the restructuring as well.
So, ma'am, my second question, you have been in the insolvency practice since years. We have had this timeline under every law, before the DRT or even under the SARFAESI. Now we have a very strict timeline, and this is one of the highlights, that the need for speed which is being delivered by the bankruptcy code. But do you think we would be able to adhere to the timelines, or what could be the practical challenges in adhering to the timelines, considering the intervention of the courts?
I would say the basic difference between SARFAESI and other acts with respect to timelines are concerned is that as far as this act is concerned, if the timelines are not adhered to, you face winding up, liquidation, period. Even the adjudicator does not have any role to extend the period beyond the 90 days which is permitted, and that also with the consent of 75% of the secured creditors. So that is a very, very major change in terms of timelines, because timelines, rightly pointed out, have been specified. And
so if the resolution process fails, liquidation is the only
automatic.
Okay.
There are only two options. Either there is a resolution plan in place, or the resolution plan gets rejected. And liquidation is automatic after that. So this is a vast difference from the other acts, and I think this will go a major way in adhering to the timeline, so to speak, as far as the process is concerned.
Does the law provide a right of appeal before a resolution? If a resolution plan has been approved by the creditors committee, can it be challenged in the
It can be challenged, but they have restricted the challenge only to malpractice or a fraud. As far as the resolution plan is concerned, they have restricted the challenge only to malpractice or fraud.
Do you think, the code has reduced the scope of judicial intervention? Where the commercial wisdom is now weighing over the judicial wisdom?
So, I will say that it's a bankruptcy is for a business, considering it's corporate, or even in case of individuals, or what are our target area? Target area is the business, whether it is be the corporate or the partnership or the MSME sector. So think like a businessman, and what are the other stakeholders? Another stakeholder is the bank, and the third stakeholder is the labor. So there has to be a time frame. In the previous frame, when the debtor was allowed to keep in possession of the assets and manage the business, but they were able to manipulate the system. So, and there were lots of instances, and we have a lot of decided cases as well, where the promoters and the directors and the management were found to have confiscated and misappropriated the assets of the company to themselves. We have decided cases to that. So certainly the timeline will be instrumental, and when the timeline is there, the adjudicating authority is bound to comply with that timeline. And apart from that, the most important aspect is we are reducing any interference by any other adjudicatory authority. There is only one adjudicatory authority for the corporates, which is the NCLT, and there is only one adjudicatory authority for the others, that is the individuals and partnership, which is the DRT.
What I feel is, different provisions would provide, particularly the one, first of all, that it equalizes different creditors. For example, whether it's a secured creditor, unsecured creditor, operational creditor, and anybody can trigger an insolvency mechanism, and that is very, very important.
That's a powerful tool.
That's a powerful tool, and I feel that is going to induce a kind of a fiscal discipline or financial discipline in markets, which is completely unheard of. For example, I come from the MSME sector, and most of our problems are related to unpaid dues. Like, MSME supply to large companies won't pay. So any small company tomorrow can take this large company through this route and can force a trigger for insolvency, and that's going to have a very different kind of discipline.
So we can say now they have a stake involved, to exercise fiscal discipline.
So when the smallest of company can take on the largest of companies, and that can have a very, you can say, benign impact on the discipline part. Secondly, putting the professionals again in comparison to, say, for example, judges, that also makes a difference, because ultimately whether a company is revivable or not, it's a commercial decision and has to come from professionals who know that how a particular business is run, rather than, for example, because there is no legal point, it's a value judgment.
Now, let's come into a very serious issue, that this entire bankruptcy code is a creditor-centric legislation, whereas in the US it's a debtor-centric legislation. So in other words, what we are saying is, if the company is going through a resolution process, an insolvency professional comes in and he takes over the management of the company. So do you think this is a huge cultural change in our country? How are we going to cope up with this, and whether this change will be successful?
So let me answer by saying that countries which are creditor-centric have already rethinking. They are finding that the creditors being involved in the resolution plan alone does not work. So it's my opinion that the promoters or the ex-management should always be involved in the resolution plan. Maybe they shouldn't have any voting rights in terms of accepting or non-accepting, but they should always be closely associated, because after all, these are the businesses they have run. They know the ins and outs of the business. And my personal take on this is that they should be associated. Maybe not in the terms of, like I said, voting rights in terms of approving the plan, but definitely, and in fact, the creditor-centric countries are rethinking and
Come back to
come back
data-centric.
to not data-centric maybe, but
maybe a middle path.
maybe a middle path.
Right.
I would say that coming from the industry perspective, the US system is shade better than the system that is proposed here. But whatever is there, even there are two different issues. If you look at the large companies, the powers of the board is suspended and the insolvency professional is in charge. But of the rest of the operational people, managers, they remain as it is. So they are running the company, like vice president marketing, vice president production, this and that. So
only the board is suspended.
the board is suspended. So there is not much of a problem. But now when the problem comes is that when you have an SME. Now MSME is management as well as the chief operating officer and the CEO. So he is the hands-on person. If you remove him, there is nothing because
left.
everything knowledge is tacit in the brain of this man. If you take him out, everything collapses. So there lies our worries. I mean, how we are going to solve this. Maybe informally they continue to work closely and cooperate with each other because ultimately it is in the interest of the person who has requested for liquidation that company ultimately survives and restructured or whatever the goal was is achieved. But there, I think, painting both the MSMEs and the large corporates with the same brush, I think is going to be having difficulties.
So because you have now raised the issue of MSME, you are happy with the final shape of the code from the perspective of the MSME sector? Do you think
As I said, I think
cater
it's
to the
a
interest?
huge development because 97% of MSMEs have been or are proprietorship partnership firms. And there were no mechanism whatsoever available for them because BIFR was for the large companies. And there was nothing for MSMEs in terms of seeking protection during the period when the restructuring is taking place. So even if I am requesting my bank and the bank is restructuring my loan, any debtor, especially the crown debts that can take me to the court, can take possession of my properties and sell them off, and it has happened often. So there was no calm period, there was no hold on period till this restructuring was taking place. So for us also, I think a very large number of firms is a huge relief that till the restructuring is taking place, there is nothing that is coming in between and disrupting the process.
So in this insolvency process, about the individuals and the partnership firms, so there is a concept of fresh start. So, but the threshold limit is too low. So do you think actually anyone would be able to?
I fully agree with you. And 35,000 rupees is too small.
It says gross annual income of debtor should not exceed 60,000.
I think I agree with you. I mean, it could have been increased, but there lies, the Act provides that this could be increased. It can be increased. Hopefully, it would be increased. But the point is, a very large number of people in India are committing suicide even for these smaller size loans. Farmers committing suicide for a buffalo loan or for some cow loan, goat loan. So, I mean, if you look at this particular provision provides for relief for people, for example, who are under microfinancing, and we have a huge microfinancing sector thriving in the country. For them, in the case of default, there was nothing. So when those were routinely imprisoned, if you look at the district magistrates, big files are there when defaults for 10,000, 20,000, 50,000 people are routinely being sent to jail. And 13-day jail or 14-day jail, and it is recurring. So I think although, we would have welcomed it had it been 4, 5, 6 times more than what it is currently in shape.
Maybe I'd like to interject one thing. So the drafters of the code have given noble suggestions, and I believe there is a big responsibility upon the government to ensure who are the most needed recipients of this scheme. So certainly there is a considerable lack of approach in the IBC to focus upon the masses of the country. And if the dispute resolution is only in the DRTs, that is in the district, and that also might not be possible in all the districts of the country, how will a poor farmer or an individual of a village consider even going to the district to file his claim? So for those people, there must be some resolution in the village, or even in some sort of a circuit court or a mobile court, something like that, which can be a hybrid of the DRT. If if this DRT concept is continued and there is no special arrangement made for the farmers or the people from the villages or small towns, then this will be a...
You have
Access would be
raised a
difficult.
very important point, because DRTs, I was just going through the statistics, there are already 60,000 cases pending before DRTs. Now with the individuals, now the adjudicating body for the individuals and partnership firms would be the DRT. So it requires for a huge, upskilling.
Yeah, so maybe the pending cases of DRTs will gradually be put on before the NCLT. But the question is, another very important aspect is the DRT itself is a non-structured entity. It's not a permanent establishment. So you need to make, so whatever establishment adjudicatory mechanisms we have in the country, they are permanent establishments, which are the Supreme Court, the High Court and the civil courts. The DRTs are not successful, and a major reason is that they are not permanent. They are renewed from time to time. We have some experiments with special courts and so on.
Vacant. In DRAT,
Exactly.
so
I
many
want to
seats are lying
interject
vacant.
because the basic cause is also that most of the seats are lying vacant. The DRTs are not functioning fully because it's not manned. That is a problem. I won't blame the institution. It's not manned. Currently, the requirement is much higher than the number of people there.
So, ma'am, one very important issue which is creating a lot of confusion is the voluntary winding up proceedings in the Companies Act, where the High Court is the adjudicatory body.
Just let me explain to you, because voluntary winding up is completely different from winding up. So under the code, what has been envisaged is that only those companies where the insolvency process has not been completed within the specified time, or with the process plan, the plan has been specifically rejected by the NCLT, will be sent for winding up under the particular act. The rest of the winding up will be carried on under the Companies Act, whether it is voluntary or otherwise. The provision with respect to voluntary winding up under the act is that where there is a default, then there is no
The code will be
triggered off. So there is no question of voluntary winding up. For the rest, with respect to whether the company has passed a special resolution for winding up, or whether there is whether the company has acted against the interests of the state, all will be governed under the Company Court.
Dr. Garg, I would like to raise this issue of the cross-border insolvency. Now, if one goes through the code, the impression is that it has only postponed it for bilateral negotiation and agreements between the countries. Now, we have live examples like Kingfisher Airlines, where the assets are located abroad. So, how are we going to tackle on whether the code has not sufficiently dealt with this issue? What's your take on this?
Yeah, they have hurriedly, as Mr. Bhardwaj had mentioned, that the code was referred to the JPC, and the JPC felt that we cannot approve the code in such a manner, so we have to have some provision with respect to the cross-border insolvency, and consequently we inserted two provisions which reflect the cross-country cooperation. So only if there is a creditor and there is if there is a debtor in my country and he has assets outside, then we have to presume a sort of a cross-country cooperation, and there has to be in place some protocols, and then only we can proceed against them. So that's an individual basis, and it's time consuming, and again that will be of a great, there will be great practical difficulty. So better and the only permanent solution is to adopt the UNCITRAL model law. If we adopt the UNCITRAL model law, there are certain concepts, for example, recognizing a foreign main proceeding or a foreign main non-main proceeding or a subsidiary proceeding, and which recognizes that is the action or the relief by the foreign creditor itself. So in case of Vijay Mallya, what we are doing now is red corner notice or trying extradition or all sort of things.
All sort of things, absolutely.
Enforcement Directorate. So
exactly, ED.
Everything we have applied it.
If we have already the law in place, so the Bangalore DRT passes an order, the creditor, the professional can take that order to the UK court and say, see, we have a asset seizure and kindly allow us to realize those assets or seize those assets, and that will be granted. That is the same thing, that is the benefit of the UNCITRAL model law. You don't need anything else.
So since we are running out of time, sir, I'll start with you. Your closing remarks. Should we take the bankruptcy code with a pinch of salt? How do you take it?
I would look at it, in terms of a lot of hope, I would say. I remember, let me share with you a small incident. 2 years ago, there was World Bank organized Asia Insolvency Forum in Philippines, and I represented India in this. And I had a fantastic experience that, the country in Asia that had sort of a leap in many commercial laws is South Korea. South Korea is considered one of the good examples. And the South Korean judge there explained through an analogy. He said, when an asset is stressed, it's like an ice of cube on your palm. So you have to act very, very fast. Do whatever is required. Provide man, provide consultancy, provide this, provide that, whatever. But it's melting. So do it fast. So speed is the most important thing.
That's the successful mantra of the code.
Yeah, so if we can adhere to that and if we can achieve that, I think we would have achieved 99% of it.
Well, I would say that it's going to be highly litigated because constitutional rights are being affected. We should brace ourselves for a long litigation and see how we can strengthen our code. One more suggestion is that many of the code relies upon subordinate legislation. So there is a need for good quality rules and regulations because many of the sections rely upon rules and regulations to be framed by central government.
In fact, the implementation is dependent on the rules
so a
and
lot of it. So we need very good quality subordinated legislation, and of course the infrastructure, the 4 pillars, as they say. There's the regulator, the DRTs and the NCLT have to be duly manned, and the IP professionals and the information utility. So these 4 pillars have to be very, very much in place.
And robust pillars.
And robust.
Before we wrap up, the Prime Minister Modi has promised that within the coming 3 years, India would break into the top 50 countries on the parameters of ease of doing business. Well, we all would like to believe that really happens. Looking at the way our parliament functions, it's really commendable at the speed at which the bankruptcy code has been enacted. But there is greater need for speed for the infrastructure facilities to come into place. Thanks to my panelists for joining in the discussion, and goodbye.